When federal Judge Beryl Howell talks, people listen. When she puts things in historical context, people listen. When she's the first federal judge to reach out and rap the knuckles of law firms who settled with Donald Trump, who bent the knee, who violated their professional ethics. And she does it in such an artful and powerful way in her new 101-page decision against the Trump administration, where she not only holds up and lauds firms like Perkins Coie and Jenner and Block and others in their fight against the Trump administration, but at the same time, she takes down a notch or two as the first federal judge has to what we watch, which is over a dozen different law firms give Donald Trump $1 billion and a talking point by settling with him to avoid being put on a blacklist or a watch list. Not Perkins Coie, not Jenner and Block, and not the rest. And the judge, in her order, and I'm going to read it to you, in her order, spent time putting this in historical context about what John Adams did, about what Alexander de Tocqueville observed about the American democracy, and the role of the independent bar, the independent lawyer, as a safeguard, as a firewall against the excesses of democracy. At the same time, naming names about the law firms who in history will now be enshrined that they capitulated to Donald Trump instead of bringing the cases to federal judges the way they should have. And Beryl Howell, who used to be the chief judge of the D.C. Circuit, D.C. District Court, is the right judge to do it. And you're at the right time in the right place. You're on MeidasTouch and on Legal AF with Michael Popok. Let me dive into Beryl Howell. How many hot takes have we done over the last several years about Beryl Howell and her courage? She's the judge that took down Donald Trump. She's the one that declared that he, more likely than not, committed crimes before anybody and stripped him of his attorney-client privilege along with his attorneys. She presided over all of the grand juries, at least 2/3 of them, about the Jan 6th insurrectionists and Donald Trump and the case in front of Judge Chutkan for election interference. She's the one that took down Rudy Giuliani and presided over the $158 million defamation judgment because he kept pushing the big lie that Donald Trump won when he lost and defamed to Fulton County election workers as a result. That Beryl Howell, the one who's been on the list for Donald Trump and lives inside of Donald Trump's brain. And this case has been assigned to her, the case brought by Perkins Coie, to make sure they're not destroyed by Donald Trump as a law firm because he doesn't like the fact that some prior partners were against him and his administration in the form of Mark Elias and Michael Sussman and others. And so he violated, as the judge just ruled in the 101 pages, violated their First Amendment right, the Fifth and Sixth Amendment rights of their clients, who have the right to counsel of their choice and not to have to say, well, I can't use Perkins Coie or fill in the blank because Donald Trump has them on the crap list and he won't let them into federal buildings and he won't give them a security clearance and he won't do business with them. I got to hire another firm. That interferes with the sacrosanct relationship between a client and a lawyer. Beryl Howell knows it. Now, let me read to you what, in the beginning, the first 4 pages, is not her order is reflected in an order, but this is the memorandum opinion. And in the memorandum opinion, she spends a considerable amount of time in the very first 5 or 6 paragraphs talking about the history of America, the role of an independent bar, not just an independent bench. You need the lawyers to be independent. This is what the government is founded on. She cited to John Adams representing 8 British officers in the Boston Massacre, a very unpopular position to take and to represent those clients at the founding of our country. But he felt he had to do it, even though he lost half of his practice, apparently as a result of it, because in our free and fair society, the foundation of it is an independent judiciary and an independent bar and lawyers. She then cited to Alexander de Tocqueville, who traveled around America in the 1830s, and he observed that it was lawyers in America that serve the most important role to protect democracy from its excesses, to be the firewall, to protect the people. Independent lawyers. And she, the judge, then went on in footnote 3 of her decision, which I don't want it to get lost to history. That's why I want to talk about it. She called out these other law firms. She said, you bring to federal judges issues about whether you think your First Amendment, Fifth Amendment, Sixth Amendment, 14th Amendment, due process, equal protection rights have been violated as a law firm, especially a law firm. You come to federal courts. You get your day in court. We will protect you, but we can't protect you if you enter into a temporary Band-Aid fix, bow your head, and genuflect to Donald Trump, who now declared himself to be the Pope. He just posted a photo of Pope Trump to insult all the world's Catholics and religious leaders. It's one thing to call yourself a king. It's another thing to cross the line while Pope Francis isn't even cold in the grave and call yourself Pope Trump. We'll leave that for a moment. And she said, you come to me, and those that didn't come to me, you clients of those law firms that gave $1 billion of tribute to Donald Trump. Think about the lawyers you're with, because they have compromised their ethics, and you have to think about whether they're going to commit to you and give you the zealous advocacy that's required under the professional rules of conduct and responsibility, or whether they're going to be a little gun shy and serve two bosses, which you can't, and compromise your position as a client because they're worried, well, one eye on the Trump administration. Don't use those law firms is what she's basically saying. And later, to support her decision, to support Perkins Coie and enter a summary judgment permanent injunction, she says, and let me just show you why their decision about retaliation and retribution is right and its impact on First Amendment expression and Fifth and Sixth Amendment right to counsel. Because look at all the other firms that capitulated. And then she named names, Paul Weiss, Skadden Arps, where I used to work, and other firms. She used them as an example, their cowardliness and cowardice as an example. Let me read to you from Beryl Howell. And then I'm going to show you a clip of Beryl Howell in action at a speech, because we don't often get to see judges. You know, their court proceedings are not recorded or not on video or audio, but I want you to hear from her directly so you know what I'm talking about. But let me read to you first from the footnote. Footnote 3. This message has been heard and heeded by some targeted law firms. The message to chill, to restrain, to don't hire people that you want to hire, to don't, because it violates DEI, to don't take on client causes the way you want to. She says it has been by the targeted firms as reflected in their choice after reportedly direct dealings with the current White House to agree to demand terms, perhaps viewing this choice as the best alternative for their clients' employees. In other words, to give free legal service, $50 million, $100 million, $150 million in some cases. Yet, she says, some clients may harbor reservations about the implications of such deals for their vigorous and zealous representation to which they are entitled. This is a warning to the clients direct from the federal judge, from ethically responsible counsel, since at least the publicized deal terms appear only to forestall rather than eliminate the threat of being targeted by the executive order. In other words, they're not out of the woods. They got the sword of Damocles hanging over their head. And if you're a client of their firm, you got to think, are they representing me? Or are they trying to avoid future ire and being on the wrong end of Donald Trump and his administration? She then says, as other former and current general counsels caution in a brief filed with the court, a fundamental premise of the rule of law is that when parties challenge the government, their lawyers oppose the designated representative of the state, and the system assumes that the adversarial testing will ultimately advance the public interest. Adversarial process, two sides fighting zealously against each other will lead to justice. But how do you do that when one side's been compromised? Only when lawyers, she says at the bottom of the footnote on page 3, only when lawyers make the choice to challenge rather than back down when confronted with government action raising non-trivial constitutional issues can a case be brought to a court for judicial review on the legal merits. Like, what are you thinking? Law firms that settle, bring it to the courts. We'll support an independent bench. We got 4 other cases out there, and the lawyers are all, and the judges are all watching. Judge Ali Khan, Judge Bates, Judge Leon, they're all about to issue their own orders. They're going to be mimicking. They should just say, see attached, me too opinion, see Beryl Howell. They shouldn't even write another opinion. They should just adopt this one. She continues, only when lawyers make that choice and bring it to ours. And then she lauds and compliments and pats on the back Perkins Coie and their law firm, because there's law firms that now have to step forward to protect law firms. I mean, Abby Lowell, Hunter Biden's lawyer, Jared Kushner's lawyer, represented the House of Representatives, go-to white-collar lawyer, Clinton investigations, those kind of things. Represented John Edwards, Senator Menendez. He just formed a new firm. He left Winston and Strawn, You know, I don't know the terms. I'm going to try to get him for an interview. He left Winston and Strawn, brought with him the Skadden Arps associate who quit rather than continue to work at my old law firm, Skadden Arps, where I started my career. I hope I would have had the courage that she has. She's now joined Abbe Lowell's firm as his first associate or his partner or whatever it's going to be. And I compliment that. And his sole focus of his law firm is to step in and defend people against politicized attacks and investigations, including he's now representing, get this, Attorney General of New York, Letitia James, who was just interviewed by Ben Meiselas here on the MeidasTouch Network, because she has a politicized, weaponized investigation against her brought by the Department of Justice and Pam Bondi for some BS mortgage fraud allegation to try to clip her wings. Not going to happen, and not with Abbe Lowell, but I continue. She compliments on Judge Howell on, she says, as was done in this case properly by plaintiff Perkins Coie and their counsel, Williams and Connolly, and the lawyers, firms, organizations, and individuals who submitted amicus briefs. There were 500 law firms that submitted briefs in support of Perkins Coie. There's 350 federal judges who did the exact same thing. She quotes from one of the amicus briefs. She says, our judicial system is under serious threat when determining whether to file a brief could be a career-ending decision. But when lawyers are apprehensive about retribution simply for filing a brief adverse to the government, there is no other choice but to do so. You must oppose at that point. And then later in the brief, in the opinion, on pages 60 and 61, she says, let's use the examples to prove this case, why it's so important that I issue this injunction. Look what Paul Weiss did. Look what Skadden Arps did. Look what Wilkie Farr and Gallagher did. It's the first federal judge. It's the first federal judge to rebuke those law firms. And I'm proud of her and proud of being a part of that same profession. Because facts matter. In fact, here's a clip of Beryl Howell just last year talking about facts matter. I want you to hear from the judge herself, since we don't have clips from the actual oral arguments. And then if you want to have more information, come over to the Legal AF Substack, because right now I've got up there posted this 101-page decision and her order. So you can go to the Substack, Legal AF Substack, support us there, subscribe there, and get this content that you're looking for. Let's run the clip of Beryl Howell.
Having a very surprising and downright troubling moment in this country when the very importance of facts is dismissed or ignored. That's a very risky business for all of us and our democracy. The historian Heather Cox Richardson, whose book I've been reading, explains in her new book, which is a bestseller, so many of you may have already read it, Democracy Awakening, that burying facts with false history telling is one of the keys to the rise of authoritarianism. As she bluntly puts it, big lies are springboards for authoritarians. She cautions in her book's opening line, it's the very first line, America is at a crossroads, teetering on the brink of authoritarianism. And she echoes this thought in her closing line, that we are at a time of testing, and how it comes out resting, as it always has, is in our own hands. In between those 2 points, in the first line and the last, her book focuses on historical facts to set the record straight about recreated and imagined conspiratorial retellings of our country's history, recent and long ago. My DC judicial colleagues and I regularly see the impact of big lies at the sentencing of hundreds of individuals who have been convicted for offense conduct on January 6, 2021, when they disrupted the certification of the 2020 presidential election at the U.S. Capitol. As district court judges, we are all about the facts.
Beryl Howell. She's speaking to history. She's speaking to you and me. She's speaking to the Trump administration. She's warning the law profession. all in a 101-page decision, and we're all here for it. You're here on MeidasTouch Network. Hit the subscribe button. Come on over to Legal AF, the YouTube channel. We're going to hit 700,000 subscribers by next week with your help. I'm doing it in collaboration with the brothers on the MeidasTouch Network. We have a dozen contributors. We just brought on as our house ethics, or house historians, if you will, Sidney Blumenthal, famous journalist, historian, reporter, presidential advisor to the Clintons, and Sid Walentz from Princeton University. They're going to be doing regular hot takes as court of history, which is the highest court above the Supreme Court in their view, giving you historical references as to why the Trump administration is full of crap. I'm Michael Popok. Hopefully you don't think I am. And I'm on MeidasTouch Network. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.